Welcome to the learners. Today we are going to discuss another important subject called the dispute redressal mechanism provided under the Consumer Protection Act. This falls under the block 4 and unit 16 and 18, which is already uploaded in our portal. Just before we get into the discussion on this dispute redressal mechanism, I would like to recall your memory about the composition of the Consumer Protection Act as a whole. The Act created three authorities. They include Central Consumer Protection Council. The primary job is to render advice on promotion and protection of consumer rights. The second authority created is called the Central Consumer Protection Authority, whose primary objective is to regulate matters relating to the violation of the consumer rights, unfair practices and restrictive practices, false and misleading advertisements. And the third machinery created, about which we are going to discuss today, is the Consumer Dispute Redressal Mechanism, that is the Consumer Dispute Redressal Commissions. Their primary job is to settle disputes. Today's discussion on this machinery only. In addition to that, there are two more procedures are provided on this mediation process and the liability, product liability aspects, about which I will be taking separate lecture. With regard to the Central Consumer Protection Council and the Central Consumer Protection Authority, a separate lecture is being arranged that you may kindly watch this slide later on. Then again there is a separate lecture is planned for the mediation, the process of mediation and the product liability, which will be uploaded in due course of time. So with this brief introduction, let us get into the today's subject, consumer dispute redressal mechanism. See, as I already said, this mechanism is provided for settlement of the dispute. That means when there will be a need for the settlement of when a issue will become a dispute. If the parties to the particular transaction, if they fail to arrive at a consensus based on their normal course of functioning, normal course of discussion and understanding, and if all the mechanisms have been tried and worked out, and if there is no machinery or no machinery is available for settling the dispute amicably, then this issue becomes a dispute. Therefore, we need a separate mechanism to handle this dispute machinery. So, dispute machinery is not the beginning, it's a middle part of it. Before entering the dispute arena, the parties should try best by themselves to settle it, resolved amicably. So, that is what the presumption is. So, once it has become a dispute, then the affected party, that is the consumer on the one side and the seller of goods and service provider on the other side, these are the parties to a dispute. So, then what is they have to, machinery is provided in the Consumer Protection Act for the establishment of consumer commissions at the district level, at the state level and the national level. And the district level, it is called the District Consumer Dispute Redressal Commission, and at the state level it is called the State Consumer Dispute Redressal Commission, and at the national level National Consumer Dispute Redressal Commission. Now, coming back to this, they have a separate jurisdiction to handle this dispute is concerned, about which we will be discussing at length. There are three types of jurisdictions before we get into this: territorial jurisdiction, pecuniary jurisdiction and subject matter jurisdiction. Is these three jurisdictions have to be fulfilled before invoking the jurisdiction of the either District Consumer Redressal Commission, I will call it a District Commission, and the State Consumer Redressal Commission, I will call it the State Commission and the National Commission. Now, what is territorial jurisdiction? We should understand. Territorial jurisdiction refers to the physical presence of the parties to the dispute within a specified geographical area. When let us relate the District Consumer Dispute Redressal Commission. So, whenever when it refers to the each district provided with a territorial district, number of tahsils, number of blocks, number of panchayats, these consist of the district. So, with regard to dispute, any person who purchased the goods either within the district concerned and also the seller of the goods or the service provider should also reside within that same territorial jurisdiction of the district's concern. Let us take the example. Let us say district Rohtak. Then there is a district consumer redressal commission is a Rohtak. Now, what about in order to invoke the jurisdiction of the district commission, what are the requirements? That means the person who purchased the goods or who hired the services either must reside in the territorial jurisdiction of the district Rohtak, and also the seller of the goods or the service provider should also reside within the territorial jurisdiction of the that particular district is concerned called Rohtak. So therefore, it is very, very necessary. You can see that within the buyer and the seller, or the buyer and the service provider should reside within the territorial jurisdiction where the opposite parties ordinarily resides, or he can ordinarily reside, or occasionally he will be coming and going. That is also possible. One way is, or the seller, the opposite party means the seller, or where he is not residing but he is carrying on the business. The person may be residing in some other district also, but for necessary purpose he is having his office premises in the district Rohtak. So even a person not residing within the territorial jurisdiction of the Rohtak, but if he is carrying on the business within the vicinity, within the jurisdiction of the district territorial jurisdiction of Rohtak, then the case can be filed against that opposite party in the district Rohtak, even though he is not residing in this district. Then, or as a branch office, suppose sometimes there are bigger organizations, they have the branch outlets, say All India persons, they have that networking. So even a branch office, the head office may be situated elsewhere, but for the purpose of invoking the jurisdiction of the district court, even that office which sells, let us say Maruti tractor or any company, if it is not necessary, we should go to that head office where it is situated, or even if there is a sale for a sale outlet is there in the district Rohtak, that is sufficient. So to invoke the jurisdiction of the Rohtak district. So that necessarily means it is not necessary the production should take place within that district. No, it is not necessary the head office should be within the same district. No, even a small outlet is present in that particular territorial jurisdiction of the district, that is sufficient for filing a case against the seller of the goods or the service provider. Or the second requirement is where the cause of action either arises wholly or in part arisen. Suppose the cause of action means where the purchase made, that may be a place of cause of action, or suppose in the case of the vehicle is carrying goods from one parts of the country to another parts of the country. Let us say that due to some unknown circumstance, the accident or due to fire, some accident takes place and the goods perished. Now, it may be in the one place, Chennai may be the origin of the goods. It may be going to the Assam, say Guwahati, but in between, let us say it is in the Madhya Pradesh, Bhopal, on the way the goods has got fire. Now, this is the manufacturer at Chennai, and the person, the buyer is at Guwahati. The goods is got fire in the, say, let us say Madhya Pradesh, Bhopal. Now, which is the place to file the case? Now, in this case, either the cause of action arises in Chennai, or it did not arise in Guwahati because the good did not reach it Guwahati. But in Bhopal, the cause of action arises partly. It is partly, fully it is not. When the goods has got fire, so therefore, where the cause of action arises, that place, there also the case can be filed. That is what these are the grounds for it. Then, where the complainant resides personally, works for gain, or the complainant means the person who making the complaint, then where he resides it, that can also become the place for filing the consumer disputes. So this is what in nutshell, territorial jurisdiction, before filing the case against the seller or the producer or the trader or the service provider, the person who wanted to file a case, he may fulfill any one or more of the requirements of the territorial jurisdiction. Once the territorial jurisdiction fulfilled, then comes the pecuniary or financial jurisdiction. That is equally important. Coming with the determined jurisdiction for filing the dispute is concerned, all the three requirements of the territorial jurisdiction, pecuniary or financial jurisdiction, and subject matter jurisdiction. All three must be fulfilled simultaneously. Now let us see to the what is that pecuniary jurisdiction of this concerned district forum is concerned. Now before that, it is better to understand the composition of the district commission also. First of all, the district commission can be established by the state government. Then if wherever cases the state government considers some district, if it is very big, then the state government, if it thinks necessary, it can constitute or form more than one district commission for the same district also. That is the constitution or the establishment is concerned. Then the composition of the commission, what should be the composition of the commission? Then in the case of district commission, there must be one president who must be a judicial person. Judicial person either is with the sitting judge or retired judge of the high district court, or an advocate who is practicing in the district level for a period of 10 years or so, and so on. The qualifications are prescribed. That is about this concern. Then the members, generally the members of the commission should be above 35 years of age. Then they must have worked in the concerned field for a say social non-governmental organization for a period of 10 or 15 years or so. The qualifications are prescribed and the act is concerned. Then coming back to the members, there must be one president, he must be a judicial member. Then not more than the number of person, it should be 2 or more. That the maximum number of person will be decided by the state commission for each district. Minimum is 2 or maximum it may be 4 or 5 or 6 or 10, it may be any number, but it should be decided by the state government is concerned. Not more than number of persons concerned. Not less than is the 2 is the minimum. So one president and not less than 2. So it must be 3 means the must. More than 3, if the state government wanted, it can fix any number of members, then they will be appointed by the state government only concerned. Then the territorial or pecuniary jurisdiction, that is very, very important. The financial jurisdiction of the state commission, it should not, the value of the money, the value of the value of the complaint, it should not exceed, not exceeding 1 crore, less than 1 crore. Value of the commodity sold or the service charge levied, along with other considerations like interest rate, even the quantum of compensation claimed, this will constitute the kitty for determining the pecuniary jurisdiction. So with regard to deciding the financial jurisdiction of the district forum, the value of the goods purchased or the service provided, the charge levied, along with that the quantum of compensation claimed put together should not exceed 1 crore. That is what the pecuniary jurisdiction of the district forum is concerned. Now, I will not waste much of the time. The same is the pattern with regard to the state commission also. With state commission again, the state government is has the power to appoint the state commission for the state. However, if the state commission feels that so there is a need to have more state commission within the state, then they can go for the regional benches. Like we have the Supreme Court, we have the Supreme Court benches in different states. We have the high courts, different benches. They have the like Bombay High Court have the bench in Aurangabad. Madras High Court has the branch in Madurai, their own branches. Similarly, the state there will be only one state commission at the state level for each state. But if however the government feels there are large number of cases pending, then have constitute branches of the state commission at different places. Of course, it should be done with the consultation of the central government is concerned. Coming back to the pecuniary jurisdiction of the state commission concerned, again the value of the goods purchased or the service availed or the quantum of compensation claimed put together it should be either between 1 crore and 10 crores only, or it should not exceed 10 crores, it should not be less than 1 crore. So this is the financial jurisdiction. That means the goods purchased, if it falls within this range of above 1 crore and less than 10 crore, then the state commission is the appropriate forum to file the case. Again, jurisdiction, there are several types of jurisdiction. Original jurisdiction, appellate jurisdiction. These are the two types of jurisdiction. Original jurisdiction means the case where the is filed for the first time. That is called the original jurisdiction. What is that appellate jurisdiction? Means once the decision is given by the court, If the decision is not say acceptable to the party concerned, then he can go on appeal before the higher commission. So that is called the appellate jurisdiction. In the case of district commission, there is no appellate jurisdiction because it is the first court in the hierarchy. However, the state commission will, in addition to having the original jurisdiction for the value of between the 1 crore to 10 crore, it will also have the jurisdiction to hear appeal on the cases decided by the district commission also. So this is about the nuts about the state commission is concerned. Now we can come to the national commission, same thing. In the case of national commission, it will be constituted by the central government. Again, they can establish different benches at the different places depending upon the requirement need. And with regard to the composition, there will be one president and not less than 4 members. So minimum members required under the law is 5 members. And if the central government wants, it can appoint or it can increase the numbers more than 5. However, that will be determined by it will be decided by the government by issuing the notification. So this is with the composition. Minimum 1 plus 4, 5. Then it is left to the central government to increase the number of seats 10 or 15 or 16, whatever the government feels it. Coming back to the pecuniary jurisdiction is concerned, again, the value of the goods or the services hired along with this quantum of compensation claimed should, if it exceeds more than 10 crore, then the case will be originally filed at the National Commission, which is seated at Delhi. And as I said, it's in addition to the original jurisdiction, the National Commission will also have the appellate jurisdiction against the decision given by the state consumer commissions. This is what in a nutshell about the jurisdiction of the district commission, state commission and national commissions. Now coming to the other aspects also, the next question, who can file the complaint? Then what should be the subject matter of the complaint? What are the nature of claims one can claim from the consumer courts? These are very, very important as well. At the same time, just there is one more the jurisdictional aspect, the review power. Review power refers to that the court which has given the decision, it has got the power to review its own decision if based on if error is committed by the courts for one reason or the other. Then the court has the power to anybody, even human being also commit mistakes. So also the courts or the consumer commission. Inadvertently, if any error or is committed by the district commission or the state commission or the national commission, as the case may be, if they say commit an error which is apparent from the record means from the decisions and all, then the same commission, whether the district commission or the state national commission, they can review its own order to nullify those errors and all. This can be by this review power can be taken away by the commission themselves suo motu, means without any reference made by anybody. If the courts itself realizes later on that we have given the improper decision based which is apparent on the record of it, they can themselves open the case for then review the case. So this is all the review power. In addition to that, if the court is not into that, the parties can also bring it to the knowledge of court that some error has occurred or that error upon the base of the record. Then therefore they can ask the commission to review to exercise its review power to hear the case afresh again before the state commission only. These are the powers is concerned. Now we'll come back to who can file a case. That is very, very important. First of all, a consumer. We have already recorded a lecture on this, who is the consumer. Please refer to that lecture so that you will understand who is a consumer. However, consumer is the person who buys the goods or hire the services for a consideration. That is very, very important. However, goods purchased for commercial purpose is not covered, and goods which is earned for livelihood, any goods purchased even heavy nature, if it's for the livelihood, then that cases can also be covered in the consumer forum. So therefore it's a consumer. Then apart from consumer who purchased the goods or hire the service, who or others can file the case. Then in addition to the consumer, a voluntary or recognized consumer association, regardless of the fact whether the consumer is a member or not of that commission, that consumer forum, in the commission, the consumer forum or any recognized voluntary consumer association can also file a case. Sometimes there are the large number of cases. I also in the case I referred about the depositors have the grievances against the bank. The bank is put into moratorium period. and the customers have been say denied of withdrawal of the deposits. Now each and every consumer cannot go before the court, it will be lengthy also. They can form an association of the affected depositors. They can go before the instead of going individually, they can float a fora, and through that fora they can say file a case also. That's one is the individual in any case. If sometime it will be difficult for the individual to fight a case individually. So if they can come together masses, like another best example, the members who paid money to the builders. Several people know that the builders promised to say hand over the possession to all the members of the 20 or 30 or 40. Now the builder, after collecting all the money, is not in a position to deliver the possession. Now is it necessary each and every case go before the consumer? Let us say 100 members paid the money. It is not necessary for the 100 members to file individual cases. In such cases, the people who have paid the money, they can come together, they promote an association, they form an association. Then based on that association, all the 100 people can place their grievances by one petition only. So it is with a view to avoid this unnecessary filing of the complaint before the consumer court also. Therefore, consumer voluntary association, they can file a case also. Then the central government, state government. State is a sovereign body. They have the duty to protect the interests of all, including the consumers. So if the consumer is not coming forward, if they are not in a position to form the association, even then the central government or the state government, on behalf of this affected consumer, they themselves can file the case before the consumer court. In addition to that, also, then in the 2009 Levy provision provided, if the consumer who purchased the goods or he had the services, and during the pendency of the cases or before file the cases, if he dies, then what will be the fate of it? Whether can the legal heir can file the case? Yes, the legal heir can also file a case for the goods purchased by his father or mother or the guardian also. So the provision is made. It is not necessary only the person who purchased the goods, he or she alone can file the case. No, even after the death or demise of this person who purchased, their legal heirs can file the case before the consumer courts. These are the type of people who can file cases before the consumer court. Consumer, any consumer associations, central government or the state government, or the legal heirs. That is the next kind. What type of dispute they should raise, or what should be the subject matter of the complaint. Very, very important. You cannot tell stories in the complaint. What is the grievances? Only the grievance should be made in the complaint. The grievance should be in the nature of unfair trade practice adopted by the trader or the seller. What is unfair trade practice? That is a practice which is aimed to fool the public that the goods is genuine or the service is very genuine or the very good and all. Very often, we come across, in the TV and newspaper, they advertise some banks, they said, you come to us, your loan will be sanctioned within 24 hours. As per the Reserve Bank of India guidelines, it is just not possible to sanction the loan within 24 hours. So this type of advertisement which comes in the paper, that we will come to us, we will sanction the loan within 24 hours. That is, it's a fooling the public. Likewise, they come and say that even the gold jewels, and they make several claims. You come to us, you purchase the gold, immediately you can sell it to us, we will pay you the full money. But if in reality, it's our own experience, after the purchase, in one very recent cases, the goods have been purchased for a marriage. But for one reason, due to unfortunate circumstances, the groom has died. But they cannot use this jewels and all. When they went back to the shop for the request to take it back and pay the money, the person who sold the goods, he said, no, we will not pay the full money, we will deduct 10% of it. Whereas when you go to the shop, they make all the promises. You purchase today, tomorrow you come and give it, we will pay you the full money. But when the real, very genuine cases, death, but they say 10%. So this type of false and misleading advertisement, this all comes under the unfair trade practices concern. So one ground is the trader or the unfair trade practices. Then the goods purchase suffered from defects. See, very often it has come to the knowledge of the court that the sellers, they sell the either old goods or the old goods in the form of, by telling that it's a new goods. For instance, vehicle case, it has come to the court also. The old vehicle is renovated, then it is sold as the new goods. So that's then which will develop the manufacturing defects. So even in my previous things also I have got about the vehicle which consumes excessive petrol per kilometer, definitely it's a defective vehicle. So therefore such now if any goods have some defects in the manufacturing or otherwise also, that can be a ground for filing the case. Then levy of the prices. If the price charge is very heavy, then the price either displayed or noticed, brought to the notice the consumer or the consumer, or if it is charged more than the price levied in the cover of this commodity. In the case also, sometimes in the brochure they tell one amount, but when you go for it, they say no sir, this excess. They definitely you have to pay more than what is given the brochure also. Likewise, this is what another one, the prices charged in excess of the displayed and all, and goods which are hazardous in nature, those are also can be a ground for making the claims and all. Then these are the some of things, sir. Then what are the nature of reliefs you can claim for? You can ask. Now we are coming nature of reliefs and remedies. This quickly you can see. This we have seen it. This slide I have discussed already. Subject matter just now I discussed. Now nature of reliefs. One is you can ask for the removal of the defects from the goods or the deficiency in the services. Or you can ask for the replacement of the defective goods. In the case of vehicle, you can ask for the new vehicle. Or you can, if you are not satisfied, no longer interested in the good, the removal of the defects, you can ask for the refund of the price. And you can also ask for the compensation or for the loss or injury suffered. I talked about the loss occurred in the case of Bhopal example. You can ask for the adequate compensation, the value of the goods, and also the compensation whatever you want. Then you can also ask for to discontinue the unfair trade practices or a restrictive trade practice. That means that you can ask the court to pass an order to restrain the person from following such unfair trade practices and all. Then withdrawal of some hazardous goods are sold, then you can ask for the court to pass an order to withdraw all those hazardous goods or dangerous goods from the market. Then also you can ask for adequate say cost of the complaint as a cost of your litigation charges. You can also ask for. So these are the reliefs or remedies provided under the Consumer Protection Act. You can claim for. With this, we conclude the discussion. We thank you once again. Please, in addition to this lecture, you see our other lectures recording also. We thank you once again. Thank you, please.